Thank you, Tosca, and thank you all for coming today. I'm glad that we have this opportunity to be here and talk about something that we really care about, and that's competition and antitrust enforcement. I'll start by giving the disclaimer that the views expressed today are mine own and not necessarily those of the Office of Attorney General. And I'm not here today to provide legal advice, not in this context at least, not here and now, but I will take questions at any point during. I like to have a give and take, and at the end I'll reserve some time for Q&A. First, I wanted to get a feel for the audience. How many people here fall into the category of procurement managers? Okay, how about contract managers? A little more. How about both? Some people do both. Okay, good. Then we're all in the right place. Tosca introduced me earlier. My name is Bret Fulkerson. I'm the managing attorney of the Antitrust Division at the Attorney General's office. I've been in the Antitrust Division since 2004, and I've handled a variety of cases, investigations, and litigation in different industries, including financial services, insurance, aviation, pharmaceuticals, and then even on down to things like pool supplies or scrap metal, highway traffic equipment. So it really runs the gamut. And that's not just me. I think any antitrust enforcer has to have the ability to jump into different types of cases. Many of the cases that I've worked on have involved government purchasers who may have been affected by anti-competitive conduct or perhaps paid more or had less options than they would have if there was a truly competitive situation. Today we're going to touch on some big topics. First of all, what is antitrust? And antitrust is a lot of different things, but we're going to touch on the major types of violations that we look for and relate that back to how it might affect you all as government purchasers and help you spot possible red flags that could suggest anti-competitive conduct. A lot of the information is going to be geared towards things to look out for during the contract procurement process before an award has been made, but also I think a lot of this will be applicable to things that happen after an award has been made. Things to watch out for as the contract is being performed and maybe as you're getting close to thinking about renewing. So I hope that it is generally applicable. We're going to go way back to the beginning. This is the genesis of antitrust. The name antitrust comes from the trusts that arose in the late 19th century in different industries, such as the oil industry. Standard Oil is a famous trust. They operated in Texas through a company called Waters Pierce, and we'll have more about that later briefly. There were other trusts, other industries that were consolidated, like the Sugar Trust. And the Standard Oil, by the way, controlled 90% of the U.S. oil refining business. And with that kind of heft, they were able to do things that other companies couldn't. And that was not usually good for consumers, either who are buying at the retail level or other competitors who want to get into the oil exploration side or wholesaling. The trust certificate was given to corporate shareholders who consolidated their shares into the trustees who were actually controlling the market, who were setting the prices, controlling output decisions. And output, by the way, is just another way to control price. And it was very efficient for them, but not for the market, because the market wasn't deciding what the price should be. Consumers weren't deciding what the price should be because they had less options. The name antitrust is an American invention since we invented this type of law. In other countries, it's now called competition law, but it's the same thing. The result of this behavior in the late 1800s was that Congress passed the Sherman Act in 1890. That was actually a year or two after several states, including Texas, passed their own antitrust laws to challenge certain types of anti-competitive conduct. Later, in 1914, the Clayton Act is another significant federal antitrust act was passed, and the FTC Act in that same year. And these days, all of these laws work together to put a stop to or try to prevent anti-competitive conduct. The United States Department of Justice has an active Antitrust Division. The Federal Trade Commission has the Bureau of Competition. You all have the Office of the Attorney General here, and other states have active antitrust enforcers too. And we try to work together when appropriate to put a stop to this kind of conduct. Antitrust law isn't limited to big corporations. We aren't just looking after companies like Standard Oil anymore, not that they exist, but it could be small companies that engage in this kind of illegal activity, or even individuals. And it can be high-tech companies, it could be low-tech, it could be a multinational company, or even just a small regional company, or one that's located that operates in a certain city. Antitrust also applies to competitive procurements, and this is something that when I come across the phrase non-competitive procurement, which I know what you all mean, but as an antitrust enforcement, I'm like, no, they should all be competitive because everybody should have the benefit of competitive options, whether you're bidding or doing a one-off negotiation or a sole source. Whatever you're getting, the good or service should be priced at or offered through competitive means. So I kind of jumped ahead a little bit. We'll touch on monopolization and illegal mergers. Monopolization means there's a company, a firm that has a lot of market share, probably, but also a lot of market power. And it has the ability to set prices profitably above competitive levels. And buyers, like yourselves, don't really have options but to pay that price. Monopolists are also able to exclude competitors so that they don't have to face real competition. And we'll provide a little bit more information on that. Illegal mergers. We review mergers to make sure that the effect of the merger won't be to substantially lessen competition. Similarly, that means that the merged entity or the acquired, let's say one company acquires another, and after that acquisition or merger, they're able to raise prices, and enough people will pay those higher prices to make it profitable. Some people might say, you know what, that's too much money, I'm not going to pay it anymore. But if that happens, that doesn't mean that it's not that it's a legal merger. It could still be illegal. But we want to make sure that if enough people have to pay that price just because of the merger, then that's not an efficient merger, that's an illegal merger that we would want to try to fix, either with a divestiture or perhaps block it if appropriate. The third point here, collusion and conspiracy, we're going to focus on heavily today because that involves marketplace participants, competitors getting together and making agreements to restrain trade in some way. And there are a lot of different ways to do it. So why do we do it? Well, antitrust laws are designed to protect competition, not competitors. We're wanting to protect the competitive process so that competition happens, and the options that result from that should be good. There should be lower prices, better quality, more choice, and more innovation. And the opposite is really not very good. As a seller, competition cuts both ways. It gives you opportunity to grow your business, to make money, but at the same time, that means other people could take your business and make sales that you would otherwise be making. As a buyer, though, I really can't think of any downside to competition because it's going to give you options and, like we said before, lower prices. And I think buyers should be thinking about these kinds of issues whenever they're buying a good or service for the first time or even on renewal. So I think that would be applicable to procurement, people that are more focused on procurement issues, and contract managers. And it doesn't mean that if you're unsatisfied with a vendor that you have to switch. It could be that you look at your competitive options, you tell your vendor that you might switch, the credible threat of switching might cause them to do a better job or give you a lower price, whatever might be appropriate. What we can't do today is step into your shoes as procurement experts and help you choose which way to buy something. If there's a violation of some procedure that doesn't involve an actual anti-competitive issue or an antitrust violation, we can't really address that. And we can't help you get the best price or the best value for what you buy. But if there is actual competition, you should have the opportunity to get the best price. Otherwise, you won't know. There might be one vendor out there who did something bad to put them in that place, and then they get to charge you more. And without some of these red flags, you might not know it. But we can only do our best. Those first two categories of antitrust violations, monopolies and mergers, we need your help. If there is a big player in whatever arena, it doesn't have to be that they're a large nationwide company. It could be that they have a lot of market power in a small, like in a city. Sometimes the geographic market for antitrust cases is very small. And we might not know about a particular monopolist, or we don't have to call them a monopolist. They can just be a dominant vendor, a powerful company that has the ability to raise prices above competitive levels. If you suspect that they are trying to muscle other competitors out, we would like to know about it. We would like to know about either formal policies that they enact or that they place on you to do those kinds of things, or even informal policies, oral. There's just a lot of different ways that they do it. If you were unable to buy a product because of these restrictions that are imposed by a big company, then let us know. And by the way, I should point out, it's not illegal to be a monopoly. Some companies just get big because they have a really good product, they invented something that nobody else invented, or they're just very efficient. So they also, once they're that big and they're a monopoly, they can set their price. It's not an antitrust violation to be a monopolist and put your price kind of high. But once you are a monopolist, there are certain things that you can't do, like enact policies that exclude other competitors unfairly. If there's a merger that could affect your options, we would definitely like to know about it. The big mergers there are reporting requirements under federal law that DOJ and FTC have to get advance notice, and we usually get advance notice of those too. And they're also heavily reported in the papers, and we keep up with that. if any of those kinds of mergers affect you, then by all means reach out to us and let us know what issues you might be facing. If there's a smaller merger though, and by the way, the reporting threshold isn't that small. It's as of this year, it's $84 million. If the combined company would be $84 million or more, they have to report it. If it's less than that, they don't. And if it's not covered in the media, then we might not know about it until it's too late. And too late might mean that the merger has already been consummated, and that doesn't mean that it's technically too late or legally too late. We can always go back and try to fix a problem that's already happened, but it is a lot harder to unscramble the eggs, as they say, once the assets have been combined. Yes?
Is it $84 million like annual revenue or combined revenue or sale?
That's the $84.4 million is this year's reporting threshold for the combined transaction. So if one company costs $40 million and another company, if their total assets are $45 million, and after the merger it would be an $85 million company, then they would have to report that.
Thank you.
Sure. And then we have investigations that are open, and we oftentimes want to talk to buyers, people who are well-versed in the industry and have, certain insight, expert knowledge about how things work. Because our job is to try to figure out how markets work. What are people's incentives? What are your buying options? And what are alternatives? Sometimes there might be a product that is offered, and if it's not available, then you're out of luck because that's the only thing. Or there might be some substitute, and if it's a close substitute, then we need to know about it. So we might reach out to you, is all I'm saying. And please pick up the phone and we'll appreciate it. Okay, back to collusion. This language, contracts, combinations, or conspiracies and restraint of trade, is pulled directly from the Sherman Act. It's over 100 years old now, and it's also in our Texas statute, and it is just a small little phrase, but there's a lot to unpack because there are so many different clever ways for competitors and market participants to restrain trade. But at the heart of it, there has to be some type of agreement, some meeting of the minds between these actors. There are sometimes false positives, though. If companies are charging the same price for something, it might, a knee-jerk reaction might be that, oh my gosh, they talked to each other and they agreed beforehand how much to charge for that thing, that product. But that doesn't exclude the possibility that those prices are transparent, they're published, and those competitors independently decided that they didn't want to compete on price, they want a price match. They don't have to pick up the phone and call each other to do that. They could do that on their own. Likewise, there could be tough, aggressive business tactics that competitors are engaging in that might cross the line into anti-competitive conduct, but it might not. It could just be that they're really hard-edged business people that are trying to grow their business. We're in that position of trying to figure out, well, where is the line? When does it lead to anti-competitive conduct, and when is it just something that we need to take a hands-off approach and let the market play itself out? And then another thing that we have to deal with is finding evidence of agreements. And usually, not always, usually violators know that what they're doing is illegal and they don't want to get caught. So they are sneaky. They try to hide that evidence. And Sometimes they're successful and sometimes they're not. And we'll get touch more on evidence later. So let's look at different types of agreements. There are two big categories: vertical agreements and horizontal agreements. Vertical agreements are typically less suspect. We're not going to necessarily prosecute vertical agreements as much as horizontal agreements because a lot of times they have pro-competitive aspects to them. A vertical agreement would be one between different market participants at different layers of industry. So a manufacturer might might agree with a wholesaler to offer its products at a certain level, or say, oh wait, if you're going to sell my goods, I don't want them to be sold for less than X amount of dollars. That is also called resale price maintenance. In the past, it was automatically considered illegal, but antitrust has taken a more nuanced view of that because there could be situations where the manufacturer might want goods sold at a certain level so that the retailers or other participants could offer services and avoid discounting that it doesn't want applied to its product. Exclusive dealing arrangements would be another one where, let's say, a manufacturer wants only a retailer to sell its products and not competing products from other manufacturers. That happens today, and it is not illegal because that retailer could decide whether or not it wants to be the exclusive distributor or retailer for that manufacturer. But if there are manufacturers with market power, a monopolist, and those kinds of vertical agreements cause competitive problems for other manufacturers, then vertical agreements might need a closer look and possible government intervention. But let's look at horizontal agreements. So we have wholesalers in this example. The arrows mean there's an agreement. It could very well be that these are all manufacturers. That would be another type of horizontal agreement. But there's usually no good reason for horizontal competitors to be making agreements with each other. And like most lawyers, I usually have to add a caveat, usually, because there are exceptions. It could be that there is a joint venture where the wholesalers have decided to get together and offer some product or service that they wouldn't otherwise offer alone. And that would be good, because if that product wasn't offered before, then you'd be missing out. But typically, wholesalers, retailers, manufacturers should not be agreeing with each other on issues like price or how many units to manufacture or offer. I guess an example here would be office supply wholesalers. An illegal horizontal agreement among wholesalers would be to charge certain prices for their office supply products. They couldn't do that. That would be per se illegal. We would want to put a stop to it. The feds would want to put a stop to it. They might even put people in jail because price fixing is one of those antitrust violations that could lead to criminal liability. That being said, a single wholesaler, let's make this vertical, the wholesaler could require all of its retailers to charge a certain price. That gets back to the resale price maintenance that I mentioned before. That would not be illegal. But then if all of the retailers agreed among themselves not to charge below a certain price, that would be a horizontal agreement. And it's sort of the same, the end result would be the same, but it would be illegal. Does that make sense? And then the problem is that the retailers have decided to set the price. They aren't setting prices based on what they think customers will pay. That's what usually drives pricing. So we want to take a very close look at horizontal agreements. Other types of horizontal agreements, we mentioned price fixing. Market allocation is one. Markets could be divided based on products or product characteristics. Markets can be divided based on customer characteristics. So a retailer might agree with another retailer not to sell to customers on, we're here in Austin, on one side of 35, retailer A gets all of the business, and on the other side of I-35, the west side, another retailer gets all the business. That would be a geographic market allocation, and that would be illegal. Another way to divide up customers would be by type. If you offer some product, let's say you offer software for government entities, and you could offer your software to all types of government entities, but this other software seller really wants to sell to ISDs, and you say, well, okay, you take ISDs and I'll take cities. I'll sell to cities. You don't sell to cities, or else I'm going to sell to ISDs. That would be an illegal allocation agreement. And then the harm would be that those ISDs don't have another option to buy from. They just have that one person. And likewise, the cities wouldn't have an option to buy from the seller that focuses on ISDs. Now, if those retailers decided by themselves, like, I don't want to sell to cities, that would be okay. I just want to focus on schools. That's my area of expertise. That would be fine. But if it's the subject of an agreement, then that is illegal. Bid rigging, are y'all familiar generally with bid rigging? How many people have to buy products through competitive solicitations? So bid rigging is another one of those classic antitrust violations that could lead to criminal liability, but not by the Attorney General's office, but by the Department of Justice or the U.S. Attorney's Office. But it's just presumed that there's going to be antitrust injury, that the victims of bid rigging are going to be paying a lot more for their goods and services than they would if there were no bid rigging. And the way bid rigging works is the companies that are responding to a bid have talked before the responses are submitted, and they've decided who's going to win. And there's a pre-selected winner, and the pre-selected winner is supported by complementary bids. These are fake bids that are intentionally higher than the winning bidder's bid. And the winning bidder's bid, by the way, it's not at a market level, because that person knows that they're not going to be facing real competition. So they take advantage of that opportunity to charge more than they otherwise would. And then their number might look good because of the complementary bids. They're even higher than the pre-selected winner's bid. And I'll have an example to show after this. Another form of bid rigging is bid suppression. A bidder might want to submit a bid for an RFP or whatever, but pursuant to an agreement with another bidder, it's decided to hold back. It said, okay, you go ahead, you submit your bid, and I'm not going to go for it this time. That is an illegal horizontal agreement that might have led to you paying more. We don't know. We don't know what that other bid would have been. But if the bidder who stayed knows that that one who is not participating is out, then they might see that as an opportunity to raise their bid because they're not facing as much competition as they were otherwise. That's bid suppression. And then group boycott would be when a group of competitors at the same level, so a bunch of retailers, a bunch of wholesalers, distributors, or manufacturers, have seen some threat. Maybe it's a group of manufacturers don't want to have to compete against this new upstart manufacturer who's got this very innovative product, and so they have told all of their distributors, if you buy anything from this new manufacturer, you can't buy our product. Now, if that message is being delivered because of a horizontal agreement among the manufacturers, then that would be an illegal horizontal agreement in the form of a group boycott. And then, there are different ways to do that, but this is these are some tried and true ways of suppressing competition. Any questions so far? So how do they make these agreements? The smoke-filled room is a classic example, but they don't necessarily do that anymore. People don't smoke cigars anymore as much. But they do send a lot of emails, not as much as they used to. Things are changing. People are sending text messages more for business communications. They definitely don't send a lot of letters anymore. When I first started, we had a lot of paper review. Now it's all electronic. And if it started out as paper, it's digitized. But we don't need signed contracts to prove an agreement. We can prove agreements based on indirect evidence, circumstantial evidence, because some of these antitrust agreements are made orally or informally. And so we can use all of these different sources of information. I have a placeholder there because there's so many new ways of communicating these days, and we don't know what it is yet, but when we find out about it, we will look and see if there's any way of retrieving that information, reviewing it to see if it would suggest or support the theory that there was an illegal agreement. Here was a piece of evidence in a criminal bid rigging trial from several years ago in the El Paso area. DOJ brought this case, and there was an assistant attorney general here that was cross-deputized to participate in this prosecution. But there was a group of door hardware manufacturers who got together on a regular basis, maybe every month. I think they might have had breakfast at a diner somewhere, and they had a bid sheet of different jobs that were up for bid in the area. And they had this clever way of deciding who was going to win which job in advance. So competitor A would be the pre-selected winner for this deal, and B would get this deal, C would get these two deals down here, and then the other competitors that were involved would then provide fake quotes, complimentary bids to make that winning bid look good. And then O, I think meant open, which means they weren't rigging that bid necessarily. But there was really there's no benefit to a government entity to be on this list, because that means that their bids aren't the subject of a competitive procurement, not a real competitive procurement, because it's been manipulated by these various actors. So what can y'all do about this kind of activity? You can be armed with information to help you try to spot illegal conduct. Look for different situations where this might arise. If there are a few vendors in the market, then those vendors would have the incentive and the conditions favorable to do something like this. If there are a lot of vendors, then it would be hard to rig a bid. If there are 20 people responding to the bid, it's hard to corral that many people and get them to do what you want. If the vendors know each other because they interact a lot, that could also be a situation where if they were inclined to cheat, they would maybe talk about it and develop a plan to do it later. So I should talk about trade associations real quick. There's nothing inherently wrong with trade associations, and a lot of times they have the potential to bring innovation and generally good develops to whatever industry they're focused on. But for antitrust purposes, they could be a minefield for competition issues. So trade associations are usually groups of competitors that have formed an association to promote that industry. And trade association meetings ideally should talk about things to generally help that industry, but they should never talk about issues like price, like how much those competitors should charge customers, or how much output they should offer to the market. If there's a trade association meeting that you're aware of, and then you notice that there's across the board price increases from vendors that didn't exist before the trade association meeting, that would be suspect. That could be a problem. That would be an example of something that happens where maybe you should pick up the phone and call us so we can find out more. It doesn't necessarily mean that there's an antitrust violation. There could be innocent explanations. Then let's say if there's a trade association that is coordinating information sharing about prices among its members, but those prices are historic. Those were prices that were offered 2 years ago, let's say, and the prices are aggregated, so you don't know which competitors were charging which. That might be okay. It probably would be okay, especially the harder it is to tie prices back to particular firms. But if a trade association is coordinating information sharing about current prices, that would obviously be a problem. Suspicious statements or behavior. You can look for similarities in bids. If there's certain language that appears in bids that would be unlikely to appear except for the fact that they talked beforehand, that would be, that could be a problem. And any of these, by the way, these red flags, I don't think that they would necessarily be slam dunk proof by themselves. They would just be a reason to look more closely, either on your own or with our assistance. If you hear about a vendor who's not wanting to bid or respond to some solicitation because they say, well, you know what, this other competing vendor will take care of you. They typically do that kind of job. I would, but we kind of have an understanding. That should make your ears perk up and maybe not ask them, well, what is that understanding? But at least we've got to look more closely at that, because if they're horizontal competitors, they really shouldn't be having understandings about who should get marketed to, who should get offered what and at what price. Sometimes vendors or businesses will say, you know what, I know that you currently have a vendor in place and I could do a better job. I could offer you that good or service for less money, but ethically I feel like I shouldn't take over your business. Account takeovers are just something that I don't want to do. Now, if that is true, then, and that is their unilateral decision, that vendor is saying, I don't like to take over existing customers, then that might not be illegal. But if they're doing that as an agreement where the other vendor has also promised that vendor that he won't take over his accounts, then that would be an illegal horizontal agreement. And those customers would lose out on opportunities to switch, or at least see what other alternatives are out there in the market. Sometimes you're expecting to get a bid from someone and they don't. Maybe they have decided they don't want to pursue that business. That's perfectly legitimate. Or maybe it's the subject of some bid suppression agreement or other agreement to restrain trade. Sometimes vendors have patterns that you can detect on where they are and where they aren't. I know that sounds sort of obtuse, but if a vendor could compete on the east side of town, but they don't, and there's other evidence to support that there's an agreement to carve up a geographic market, then we'd want to know about that, because it might limit your options. And then vendors will request information. We know that. It's not necessarily wrong, but if they're doing it so that they can share the information with co-conspirators, then that in and of itself might not be evidence of an agreement, but it could lead you back to the group of conspiring vendors and find out more about some anti-competitive agreement that they have. So just know that whenever vendors are looking for information, it may or may not be suggestive of some other competition concern. Sometimes bids are really high, and that's just because market conditions have changed. Input costs have increased, or there's some scarcity of a product, or there's more demand for a product. But sometimes they're higher because, lo and behold, there's been an agreement beforehand that the bid is going to be high. There's a pre-selected winner, and the other bidders are submitting fake bids. Those fake bids might have a consistent difference between the winning bid, either in dollars or a percentage difference. And I think we've already talked about these kinds of geographic area allocations. Quick word about tie bids. Has anybody ever gotten tie bids on a competitive procurement before? Sometimes it happens, and it could be explained by the fact that there's some component of the bid is a commodity or a uniform price, or it's a service that vendors usually offer at a certain price, and depending on the RFP, it might be legitimate. But if it is highly unlikely that two vendors would submit, $1,349,000.17, then we should find out why that happened. And if it's likely that they talked beforehand, then they may have violated the law. So what can y'all do? When possible, avoid tight specs. Draft your RFP so that you can get the most participation, take advantage of competition by seeing, what are your options? Who are the vendors that offer competitive responses? And don't try to limit yourself by writing the spec in such a way that only one manufacturer or supplier can provide that. And that might mean that you have to talk to your end user, somebody in your agency that really likes the ABC Corp pencils. And you know what? There are other pencils that are pretty good. I guess that's not a good example because we have certain source for pencils for the state. But you know what I mean. And then sole source, that sole sourcing isn't necessarily an antitrust issue, but if you are going to do a sole source procurement, you should make sure that it is actually a sole source kind of product or service, because if there are options, you would probably get a better deal. And if it is a sole source, then that might mean that they have monopoly power, and there could be things that they are prevented from doing, but they would be able to charge more. Advertising in a variety of ways, not just ones that you're required to use, could increase your options and responses. And insisting on procurement procedures. I mean, these procedures are designed to get best value and take advantage of competition, usually, some of them. And if there is a competitive market, then I think that would be the best way to take advantage of it. And then maintaining procurement records will help us, because if there isn't a competitive market and there was a violation, then we will be able to go back in time, look at data, look at different documents that were created to piece together what happened. Sometimes cost estimates are requested in advance of the contract award. For antitrust purposes, you know, if there's an anti-competitive conspiracy, then a cost estimate would just be an easy way for a violator to say, okay, we see your cost estimate is X, then my response is going to be X plus 200%, because I know that you're not going to get any other real offers. And likewise, disclosing the identity of vendors that might respond could come back to haunt you if a potential antitrust violator thinks that there are a whole lot of vendors that might respond to your request, then they might not see you as a soft target and try to manipulate the system and charge you more than you ought to pay. Something else you can do about collusion is include assignment clauses in both in your RFP and in the contract, and also antitrust certification statements. The assignment clause is something that allows your agency to recover antitrust damages. Let's say that you bought from a wholesaler who paid more for its products because there was some price fixing agreement among manufacturers. Without the antitrust assignment clause, you couldn't recover for those overcharges, even if that wholesaler passed all of those overcharges on to you. With the assignment clause, you can step in that wholesaler's shoes and with our help possibly, or some other antitrust enforcers' help, recover that money. And then the antitrust certification statement is required to be included in your RFPs under the government code, and it basically requires vendors, contractors, companies responding to your request to certify that they haven't violated the antitrust laws and they haven't communicated directly or indirectly with any competitor about that proposal. So it's sort of the honor system, it sounds like, because companies that violate the antitrust laws are also likely to violate, are likely to lie about it, because they, you know, who's going to admit to that? But one benefit to that would be that if they are later discovered to have violated that certification statement, then the contract could be voided, and there could be other ramifications too. So if you aren't including those in contracts or you have questions about it, please reach out to us or have counsel or other lawyers in your agencies reach out to us to see what we could do. I know that those are recommended or to some extent required for state contracts. If they're local governments in attendance, they might not be, but it still would be a good practice to include those kinds of provisions. What happens when companies or individuals are found to have violated the antitrust laws? Well, before they're found to have violated it, they might have to submit to an antitrust investigation, which is no walk in the park. These usually take years. Antitrust targets have to produce a lot of documents. They have to hire lawyers, and there's a great expense to that. And for that reason, we have to be very careful and be sure that we know what we're doing, that we think that there's the real possibility that there was an antitrust violation. And if it turns out there was, and at the end of our investigation, we think we have evidence to prove it, then we could prosecute them. We could file a lawsuit to recover damages, to get an injunction. They could also face prosecution from the feds, DOJ or FTC, other state attorneys general, or private litigants, customers, or class action lawyers. And at the end of that case, they could have to pay treble damages, so that if they overcharge customers, if that conspiracy resulted in customers being overcharged $1 million, the wrongdoers would have to pay $3 million in addition to attorney's fees, penalties, and investigative costs. And then they could also be debarred from doing business with the government. That's a big stick. I don't think most vendors who specialize in government business want to ever be on a debarment list. And if it is a classic per se antitrust violation like price fixing, bid rigging, some people end up going to prison, and that would be definitely another reason to not get involved in that. So, are there any questions so far on anything? If you have questions later, don't hesitate to call me. Nick and I left business cards back there, and I have my contact information here. Please, if you have questions, concerns, even if it's an inkling, not a full-blown red flag, feel free to call us. We like to chat about these kinds of competition issues. And then use these tips to help protect yourself and your agency, and then help us as we do our job and look at different issues, either monopolization investigations, mergers, or these kinds of conduct investigations. Okay, thank you very much.